All right, a federal judge just did something that doesn't happen quietly. It doesn't get buried in a procedural footnote. It doesn't get softened by careful legal language designed to protect everyone's feelings. It lands hard, in writing, on the record. And what landed this week isn't a warning. It isn't a rebuke wrapped in judicial courtesy. It's a note. One note. Released. And the silence that followed inside certain rooms in Washington was the loudest thing that's happened in this case since it started. I've been inside the filings since the note surfaced. Read the surrounding context 4 times. Not because it was difficult to understand, because the implications kept expanding the longer I sat with it. Here's what the coverage isn't capturing. The note changes the architecture of the pressure. That's the part nobody is explaining with enough precision. It's not just that Bondi looks bad. It's that the note makes a specific set of people look bad in a specific way that they cannot walk back through a press statement or a Fox News hit or a carefully worded DOJ spokesperson release. The note is in the record, and the people whose names live near that note are now attached to it permanently. Trump allies froze. Not because they were surprised by the legal challenge, because they read the note and understood what it documented. I'll get to exactly what it says. But first, the background you need to understand why this particular document carries the weight it does. Pam Bondi arrived at the Department of Justice with a mandate that wasn't subtle and wasn't designed to be. The people who put her there didn't want subtle. They wanted a department that moved in a direction. Their direction? The theory was that the DOJ had spent years being managed by people whose loyalties were distributed across institutional norms, career traditions, and legal frameworks that didn't serve the administration's agenda efficiently enough. Bondi was supposed to fix that. Loyalty-forward legal leadership. A department that understood where the political center of gravity was and operated accordingly. That's not a secret theory. It was stated publicly, repeatedly, by people who were proud of it. What the judge's note now documents is what that theory looks like from the inside when it runs up against the thing it was designed to suppress. Independent legal judgment. The kind that career attorneys exercise, not because they're political opponents, but because they're officers of the court whose professional obligations don't bend when someone at the top of the org chart wants them to. Here's the timeline that built toward this moment. 10 weeks ago, a series of enforcement decisions inside the DOJ started generating internal friction. Not public friction. Not the kind that surfaces in congressional testimony or inspector general reports. Internal friction. The kind you only see in emails, in meeting notes, in the kinds of documents that people write when they believe they're writing for colleagues rather than for federal judges. 7 weeks ago, a watchdog coalition filed a formal challenge, not to a single decision, to a pattern. Their argument was structural and precise. The enforcement choices being made weren't the product of legal analysis applied to factual records in individual cases. They were the product of a predetermined orientation being applied consistently across a category of cases regardless of what the legal analysis would independently produce. That's a serious claim. Federal courts treat it seriously when the evidence supports it. The evidence here supported it. 5 weeks ago, the court entered a sealed evidentiary phase, both sides submitting documentation. Internal documents. The kind that aren't usually visible to anyone outside the department. The kind that show you not what the department said publicly, but what the department said to itself. The docket entries during this window were minimal. Sparse administrative updates. Nothing that told you from the outside how significant what was being reviewed actually was. 3 weeks ago, a supplemental brief landed. The public version had 22 pages of redactions in a 50-page filing. 22 sealed pages. When almost half a legal brief is redacted, the unsealed portion is a summary of the argument. The real argument is in the sealed pages. The court read the real argument. 10 days ago, a closed hearing. 4 hours and 40 minutes. Both sides present. No public access. The docket entry was 3 lines. The proceeding lasted nearly 5 hours. That ratio, 3 lines of documentation for a 5-hour substantive proceeding, tells you how sensitive the material being addressed inside that room was. Then the note dropped. Not the full ruling. Not the structural injunction. The note. A judicial communication attached to a preliminary order that the court used to signal to both parties and to the public record what it had seen in the sealed documents and what it intended to do with that information going forward. The language in the note is measured. Federal judges write in a register that avoids the rhetorical escalation of political speech. They choose words carefully because their words live in a record that gets argued over for years. Measured language from a federal judge can still be devastating when you understand exactly what the measured words are doing. Here's what the note communicates. The court reviewed internal communications from senior DOJ leadership during a defined window of decision-making in the affected case categories. The court found, in the note's precise formulation, that the communications reflected a decision-making process in which the conclusion preceded the analysis. Not every time, not in every matter, but in a pattern sufficiently consistent and sufficiently documented that the court could not characterize it as isolated or aberrational. Conclusion preceded analysis. In a judicial note, that phrase means something specific and something serious. It means the people who were supposed to be weighing facts and law and precedent and institutional obligation had already determined what the outcome was going to be before they went through the motions of the analysis. The analysis was performance. The decision was already made by something other than the law. The note doesn't name what that something other was in those specific words. It doesn't have to. The context of the surrounding filings makes it explicit. The aligned internal communications, the pattern of outcomes, the documented routing around of career attorneys who raised contrary views, all of it is in the record the note is describing. And the record is not ambiguous about what drove the predetermined outcomes. Political orientation. The same phrase the district court later used in the full ruling. Political orientation as the driver of litigation decisions inside the United States Department of Justice. Now, Bondi specifically. The note is careful in the way judicial notes are careful. It doesn't put her name in the operative language. Federal judges understand that direct personal attribution in preliminary orders invites challenges that can become the story rather than the substance. So the note references senior departmental leadership during the relevant period, and it references decisions that were made at the apex of the department's authority structure. There is one person at the apex of the DOJ's authority structure. There is one person whose leadership period matches the documented window. The note is not difficult to decode. And the people in the rooms that went quiet when this note circulated decoded it immediately because they were in those rooms. They were in some of those meetings. They sent some of those emails. They knew what was in the sealed documents because they were present when the sealed documents were created. That's why the freeze happened. Not because the note was a surprise in terms of its conclusions, because the note confirmed that the court had seen what they had been hoping the court hadn't seen. The reaction from Trump's allies in the legal and political orbit around the DOJ was not a coherent counter-offensive. It was a pause. The kind of pause that happens when people who are very good at constructing narratives on short timelines find themselves unable to construct one. Because the foundational problem with constructing the narrative is that the judge has already read the source material. You can dispute an interpretation when the underlying document hasn't been seen. You can say the characterization is unfair, that the context was misunderstood, that the critics are operating from partisan framing. None of that works when the judge holds the documents and the judge has already written about what the documents show. The dispute has to go to the facts, and the facts are sealed in a record the judge controls. 8 hours after the note circulated, a senior administration spokesperson issued a statement. Separation of powers. Executive discretion. Judicial overreach. The familiar framework. 12 words about the substance of what the note found. 63 words about the procedural authority of the court to issue such a finding at all. But they're still inside the institution. They still have to file papers. They still have to represent the United States in courtrooms across the country. And they do it under an institutional cloud that a federal note has now made visible in the public record. That's not nothing. The institutional harm here isn't just to the people at the top whose names live near the footnotes. It's to the people at the bottom of the hierarchy who kept their integrity and are now professionally associated with findings about the integrity of the institution they serve. The administration's internal response to the note has been, according to multiple reports circulating in legal media, a combination of legal preparation for the appellate stage and political preparation for the oversight stage. Legal preparation, because the appeals court is the path to neutralizing the structural injunction the full ruling is going to impose. Political preparation, because the congressional dimension of this is becoming unavoidable. The oversight committees are not going to let a federal judicial note describing a DOJ that functioned as a vehicle for political priorities sit unanswered in the record. Not when their members are already in an adversarial posture toward the administration on institutional independence grounds. The note is going to be read into the congressional record. It's going to be the foundation for document requests. It's going to be cited in committee hearing opening statements. And the DOJ is going to have to respond to it in contexts that the court proceedings alone don't control. That's the expansion the administration's political team was calculating when they saw 12 words about substance and 63 words about procedure in their initial response. They're already thinking about the congressional theater. Because the note isn't just a legal document. It's a political event. And political events in Washington generate downstream consequences that legal strategies alone can't fully manage. Here's the constitutional argument that deserves real engagement rather than dismissal. The separation of powers concern is genuine. The Supreme Court has protected prosecutorial discretion as a core executive function in ways that make judicial supervision of DOJ decision making constitutionally fraught. The argument that a federal district court cannot impose documentation requirements and monitoring obligations on how the executive branch makes litigation decisions is not frivolous. It's serious. It has real doctrinal support. Justices across the ideological spectrum have expressed concern about judicial overreach into executive prosecutorial discretion. The court anticipated this. Page 8 of the note addresses it directly. The court writes that the constitutional concern about judicial supervision of executive prosecutorial discretion assumes that what is being supervised is in fact prosecutorial judgment. The court found that the process it reviewed was not, in the relevant sense, prosecutorial judgment. It was predetermined outcome implementation, dressed in the formal clothing of prosecutorial judgment. The constitutional protection that attaches to the genuine exercise of prosecutorial discretion does not attach to a process the court found to be its simulation. That's the pivot. And it's a significant one. The court isn't claiming authority to supervise genuine legal deliberation inside the DOJ. It's claiming authority to respond to a documented finding that genuine legal deliberation wasn't what was happening. Whether the appeals court accepts that distinction is the central legal question going forward. But the district court's answer to the constitutional objection is not a dodge. It's a direct engagement with the most serious argument against what the court did. The appellate timeline is now the critical variable. The government's emergency stay petition is in the circuit. The note created an accelerated briefing posture because the full ruling's 60-day compliance window starts running from publication. And the government needs appellate relief before that window closes if the stay petition is going to have practical effect. The circuit doesn't have unlimited time to be silent on this. The procedural math makes the next 3 weeks decisive for the stay question category of its litigation activities while simultaneously prosecuting the appeal. The compliance process and the appellate process run in parallel. Every decision made inside the compliance framework during that period becomes potentially relevant to the 9-month review the district court has already scheduled. The government clearly prefers the first scenario. The note they're now responding to makes the first scenario harder to achieve, because the note documents the evidentiary foundation of the full ruling in advance, giving the circuit less room to claim the district court acted without adequate factual basis. That's what the note does strategically for the challengers. It preloads the appellate record. It makes the stay argument harder by establishing in the public record, before the stay petition is even fully briefed, that the district court's findings rest on specific sealed evidence that the court has already characterized with precision. Here's what the watchdog community is doing with this in real time. 3 separate organizations have announced formal monitoring efforts tied to the compliance requirements the full ruling will impose. FOIA requests are already in the pipeline targeting decision records in the affected case categories. Former DOJ officials from multiple administrations are being retained as consultants by oversight-focused advocacy organizations to evaluate whatever compliance framework the department ultimately presents. The third-party scrutiny infrastructure is assembling itself in parallel with the legal proceedings. By the time the 9-month review hearing arrives, the court is going to have access not just to the DOJ's own compliance documentation, but to independent analysis of whether the documentation reflects genuine process change or sophisticated performance of process change. The court built the 9-month review into the structure of the injunction precisely because it understood that genuine compliance looks different from performed compliance over time. The longer the monitoring window, the harder it is to maintain the performance without the performance revealing itself. 9 months of documented decision-making in a category that is being actively scrutinized by both the court and third-party monitors is a very long time to sustain a fiction if the underlying process hasn't actually changed. The judge who wrote this note has read the internal communications from the period the challengers were concerned about. He knows what the department's internal discussions look like when the orientation is predetermined. He has a reference point for what he's going to be evaluating compliance against that he wouldn't have had without the sealed evidentiary phase. The compliance evaluation isn't going to be abstract. It's going to be comparative. And the comparison point is sealed in a record that the judge holds. Here's where the freeze among Trump's allies begins to make complete sense at a strategic level. The problem with the note isn't what it says about the past. The problem is what it implies about the future. Every senior administration official who is now involved in DOJ litigation strategy in the affected categories is operating with the knowledge that internal communications are documentable, not theoretically documentable in some future hypothetical congressional investigation. Actually documentable right now in a proceeding where the court has already demonstrated both the willingness and the ability to obtain and review sealed internal records. The administration's allies aren't frozen because they don't know what to say publicly. They're frozen because they don't know what to say privately. Every email about how to approach a case in the monitored category is now being written with the awareness that a federal judge might eventually read it. Every meeting note, every strategy session, every informal discussion about litigation posture. That's a fundamentally different operating environment than the one that produced the internal communications the court's note describes. And the people who produced those communications, who said what they said in the confidence that it would stay internal, are now in the position of having to function inside the legal apparatus they built while knowing that the apparatus is being watched. Good faith legal strategy doesn't fear being watched. The watching is only a problem for the other kind. Let me be precise about what's actually going to unfold in the weeks ahead. The Wednesday conference the court scheduled is not public, but its aftermath will be. the number of compliance-related orders that emerge, the specificity of the documentation requirements the court imposes on the preliminary framework, the timeline adjustments, if any, that the court grants or denies in response to whatever the DOJ presents as its initial compliance posture. All of that will appear on the docket. And people who read dockets the way some people read tea leaves will be reading every entry. The appellate response to the stay petition tells you how the circuit is reading the district court's foundational credibility. A fast denial is a signal. A fast grant with conditions is a different signal. A slow decision with a request for more briefing is a third signal. Each of those signals tells you something about where this is heading legally and how long the compliance process is likely to run before it encounters a meaningful judicial interruption. And then the 9-month clock. September. The review proceeding. A judge who has read the original internal communications evaluating a compliance record built over 9 months of monitored decision-making with third-party analysis sitting alongside the government's own documentation. That's not a proceeding the administration can afford to walk into with performed compliance. And it may not be a proceeding they can walk into without their senior leadership's internal communications from the compliance period also being available for court review. The note wasn't the end of anything. It was the establishment of a factual foundation that everything subsequent will be built on top of, or measured against, or evaluated in light of. The court released it not to close the case, but to anchor what comes next to a documented evidentiary reality that can't be wished away or outpaced by a favorable news cycle. Bondi is under pressure not because of what her opponents are saying about her. She's under pressure because of what a federal judge is saying about the internal communications of the department she led. Those are two very different kinds of pressure. The first kind you can fight publicly. The second kind you have to fight in the record. And the record is the judge's territory. The allies froze because they understood the difference. Because some of them helped create the record. Because they know what's in the sealed documents that the note is summarizing. And because they understand that the next document the court releases is going to say it all with even less restraint than the note did. That document is the full ruling. It's coming. The note was the preview. The preview alone was enough to empty certain rooms of conversation. The full ruling will fill the silence with something permanent. I'll be in the filings when it drops. Not waiting for a segment. Not waiting for the panels to weigh in. The analysis moves when the documents move. Right now, the documents are moving faster than the coverage by several news cycles, and the gap is widening. Wednesday's conference. The circuit's stay decision. September's review. The 18-month clock behind all of it. The note was released. The record is building. And somewhere in a Washington building where senior legal officials are being very careful about what they put in writing right now, everyone has already read exactly what I just told you. Stay close. Because what the judge signaled in that note is only the beginning of what the record is going to show.